Let us look at a case study on non-resident taxation, power of the AO to hold that poem of non-resident is in India. So XYZ BV, a company based out of Netherlands, executed certain infrastructure projects in India from 2014 to 2019. It has been filing its income tax return as a non-resident, due to which the beneficial provision of the treaty results in payment of nil tax by XYZ BV. So there is a company XYZ BV. It is based out of Netherlands and it is entitled to the benefit of the treaty. It has been claiming shelter under the treaty and therefore it has not been paying any tax in India, even though it has been working for the last 5 years. The assessing officer, having jurisdiction over XYZ BV, came to know on 30/3/2019 that all the projects of XYZ BV were ending on 31/3/2019, but was of the opinion that XYZ BV had a place of effective management in India. So the assessing officer is of the view that this company has a poem in India. What the impact of a poem is that the income which is earned by this company may be liable to tax in India. AO accordingly issued a notice to XYZ BV on 30/3/2019, asking it to show cause as to why it should not be treated as a tax resident of India, given that its poem is in India. When would such a notice be valid notice? Now, the question which is asked here is that if there is a foreign company and the AO believes that it has a place of effective management in India, and for the purpose of the taxation of such foreign company, he issues a notice to such company, what, if any, will be the procedure for issuing such a notice? And when would such a notice be a valid notice? Now, under the provisions of the Income Tax Act, in order to ensure that the provision of POEM, the place of effective management provisions, are not misused by the tax office, or rather the tax officer, and are not applied in each and every case, the assessing officer shall seek prior approval of the principal commissioner or commissioner before initiating any proceedings for holding a foreign company as resident in India on the basis of its POEM. So in order to ensure that the assessing officer who actually issues a notice to a foreign company that your poem is in India and therefore you should pay taxes in India does not misuse these provisions, there is a requirement that this shall be applied only in specific cases. And second is, before the AO issues such notice, he has to obtain a prior approval from the principal commissioner or the commissioner. In this question, there is nothing which has been given to you as to whether the such notice has been given after the approval or before the approval. Therefore, it can be said that if the AO has not obtained the prior approval, the issue of notice will be invalid. But if he has obtained the prior approval, then in that case, the notice issued for the purpose of assessment of foreign company as a tax resident of India on the basis of POEM will be a valid notice. Now, just because a notice is valid does not mean that the POEM is established. You'll still have to apply all the taxes, all the tests relating to whether a foreign company is having a place of effective management in India or not. But the notice will be valid if the prior approval has been obtained.